I'll just introduce the session and then we'll go to get into the business. So, yeah, welcome to the reconvened hearing. I'm Gary Ray, I'm the chair of the panel. With me is Commissioner Jim O'Malley. The other commissioner, Commissioner Walker, is absent. We've arranged for him to view the session, which is being recorded on a YouTube link, and he'll take part in deliberations after the conclusion of the hearing, after the process has been concluded. So basically, Commissioner Walker will catch up. He has conveyed his earlier questions to us, so he's taken part in that part of it as well. Now, the reasons we've reconvened this hearing have been conveyed through the panel's minutes 17, 18, and most recently minute 19. The focus of this reconvened hearing is on the new NPS, highly productive land, or we'll just call it the NPS, which this panel is directed by and must reflect in our decision-making process. So that's the focus of this meeting. The other comment I'd make is, as mentioned in the minutes, we issued the panel's keen to run an efficient process and not to be unduly delayed by the NPS, but to build it into our process as efficiently as we can. And we also want to run a process that's fair to all the parties so they can respond to it. Now, specifically, we've initiated a two-stage process. Stage one, DCC has provided a legal submission to address which sites it considers are affected by the NPS. Submitters have provided their own legal submissions on that, and the panel's required to now consider and make a determination on which sites it considers are affected. So that's part of stage one. We have received submissions from DCC, including a memo from the reporting officer, which sets out the sites which have a percentage of highly productive land, and that was provided to the parties. Varying percentages, starting at 100% and ranging right down to 0.21%. So there has been a list provided, but we haven't received any evidence. It's purely a factual list, if you like. And we've received submissions from DCC, Gladstone Family Trust, Otago Regional Council, and most recently Outram Development Limited, Peter Doherty and CC Otago Limited. Now, that latest legal submission came in, I think, on Tuesday or Wednesday afternoon. The panel did give leave for that to come in late. And as a result of that, we haven't actually identified any questions of that submission in advance, but we will have some in today's session, and we'll ask the parties to also comment on that as well. So going back to the process, the last part of our first stage process is for the panel to review those legal submissions, ask questions and issue a determination on which sites are affected. And then stage two, we'll issue a decision or determination addressing which sites we believe are affected and direct evidence in relation to those. If they're assuming that there are some that are affected, we have to make a decision on that. And then if that is the case, we'll ask for a supplementary Section 42A report to address the NPS and invite the submitters to provide evidence and submissions in relation to that. So that's a quick rundown of what the process is. And now we go to the submissions that we've received. And before I go to that, we have received representations from the planning consultancy firms Emma Peters and Patterson Pitts, representing their clients on various sites. They have basically relied upon the legal advice of their legal counsel to promote the view that their sites are not affected by the NPS. But as I understand things, or as the panel understands things, the sites that have been identified in the officer's minute or the table are not contested, as I understand things, in terms of they do have a proportion of HPL, of highly productive land, on them. So we're not talking about evidence today, but I understand the position to be that that they are the sites that will be up for consideration, whether they're in or out, basically. Now, so moving on, we've also received some some other submissions from other submitters, but are not legal submissions, and they're from Christopher Girling, Susan Broad, Margaret Henry, and Alice Maley. And there may be others, but the other ones I've noted. Those will be considered at a later session, but the panel is minded that you have made some representations. We're more concerned today about the legal principles, so that's what we'll be focused on at today's session. Right, on that note, are there any questions from the parties on the process before we move into the legal submissions? Do we have any questions on the process?
Yes, Commissioner Garbutt here. I just wanted perhaps if you outline how you'd like to proceed today. I had assumed, because I'd led off with submissions initially, I haven't had the opportunity to respond to the other council and felt it was fair that I do so. And I suppose in doing that, I would be really addressing the questions that you'd raised at the same time, and then perhaps other council can follow. That's my suggestion, if that suits you, Commissioner.
Yes, I thought that was what I intended, was to basically run in the order that is set out in minute 19. It would make sense for the DCC to commence, because you made the first submission and people have sort of responded to that, I guess. But we'd also give you the opportunity to answer the questions we've identified and to make any other comments you wish to make on the other submissions that have come in. And those are all related. The questions have arisen from those other submissions. There might be one or two other questions that have arisen from the latest one that came in from Mr. McLaughlin that I could pose to you as part of your turn, I guess. Does anyone have any difficulties with Mr. Garbutt leading off? So we'll do that. In that case, we'll do that. Thank you. All right. Now we've read your submission, Mr. Garbutt, and I think it goes up until about paragraph. I've written down it goes up to about paragraph 19, and then from 20 onwards, I think it relates more to the considerations that we'll have for the next stage. Is that correct? So you're up to about paragraph 19. Yep. And feel free to cover the other things, but we're mainly concerned with the NPS's directions as to which sites are affected at this stage. And so, yeah, we'll hand over to you, and you've seen those earlier questions that we had identified. How did you want to present that? I'll leave it in your hands, really.
Yes, well, if I just address you orally, Commissioner, and
sure.
Good morning, Commissioner O'Malley. You've obviously pre-read my written outline of submissions. I don't plan to read through that at all, but I do want to address you on some of the issues that have been raised in reply to that, and obviously the questions you've raised in your minutes. So if I just work through in that order, and obviously the key issue for you is to determine the extent to which the NPS does apply to the sites that have come in by submission or not. And so, as I've outlined in my submission, the Dunedin City Council staff position is, as I've outlined, that it's considered and submitted to you that the NPS applies to those sites that were identified in the variation adopted by council when notified, and the exception in the NPS does not apply to those sites that submitters have asked to be added, and that it's our position that the task for the Commission is to, when you evaluate the merits of those sites that have come in by submission, you do so in light of the new national guidance that the government have issued in the NPS. That's the nub of the issue. Now, we need to address how we get to that and the different interpretations of that. And if I can start, I hope you've got in front of you or handy the NPS, because I'll refer to it and I'm sure other council will too. If I can start probably by addressing one of your questions, and that was whether there is an overall purpose to the NPS that helps us interpret it. And my submission to you is there is no express purpose like we see in some statutes, like the RMA has an overarching purpose. But what it does have is a single objective, and that's objective 2.1, that highly productive land is protected for use in land-based primary production, etc. So that's the objective of the NPS, And in my submission to you, it's appropriate that any issues of interpretation where there is ambiguity, which is being argued in front of you, if there is ambiguity, you should favour an interpretation that better gives effect to the objective rather than favouring an interpretation that frustrates the objective. And that's an overarching sort of position in the sense that the government have established an objective to protect highly productive land. It's quite a directive objective. And it's my submission as I'll go through that the council's position of that's been submitted to you in writing is more consistent with achieving that objective, in that when you come to consider the merits of sites that are sought to be added to variation 2, it's appropriate and you should assess those sites in light of the objective and the policies. It is consistent with the interpretation I've advocated for you, because it's right in light of that national guidance to ask yourselves the question of whether the sites to be added by submission do in fact achieve the objective and policies or not. So that's the overarching position.
Okay.
If I can turn then to the wording of the NPS, and obviously everyone's referred you to clause 3.5, subsection 7, which is the provision that identifies when there are exceptions. And what I want to highlight to you in this phrase, or in this paragraph, if you can turn to subsection 7, and I'll just go through and highlight some of the words that I think are important in terms of the interpretation. And it really kicks in the first paragraph of paragraph 7 halfway through, where it identifies that the consent authority, and you stand now in the shoes of the consent authority, must apply this NPS as if references to highly productive land were references, and I highlight to land, and it's important to remember that we're talking about land, that at the commencement date, and then it's obviously zoned rural production or LUC 1, 2 or 3, and then the exceptions in B is not either identified for future urban development or subject to a council initiated or an adopted notified plan change to rezone it. And I highlight the word it, and it's a small word, but it's important, because what it means is it's referring back to the land in the chapeau or the starting provision in clause 7. So we're talking about land at the commencement date, subject to a council initiated or adopted notified plan change to rezone it. And by the it means to rezone the land. And so putting all that together, it's my submission that what is intended here is that at the commencement date, so that's the commencement date of this NPS, land needed to be subject to a council initiated or adopted plan change to rezone it. And
right,
what it's talking about in my submission is that it's the decision of the council that either initiates or adopts the plan change seeking to rezone the identified land. And that is the exception. And so my submission is that it doesn't extend to other pieces of land that submitters have identified should be added. And I say the rationale for that is because the legislature has identified that it's council initiated or adopted. So the legislature, for reasons that we don't know, but it, in my submission, has identified that where a council has initiated or adopted a plan change and notified it as at the commencement date, that's a significant known event that the legislature has targeted to say, well, it's the land subject to those processes that the council has initiated and adopted relating to the land seeking to rezone it is exempt. The other thing I just want to say to draw on that same theory is that the second exemption in clause 7b Roman 1 to land identified for future urban development is the second exemption. And there's a similar theme in that. So future urban development is also defined in clause 1.3. Relevant here, it exempts any land identified in a strategic planning document suitable for commencing urban development and at a level of detail that identifies the boundaries. Now, importantly, strategic planning document is also defined in clause 1.3. And I want to take you to that because that's an important definition. It's in clause 1.3, a strategic planning document is defined as meaning any non-statutory growth plan or strategy adopted by local authority resolution. And so reflecting on what I just said about the district plan, you'll see consistency here with this definition that a strategic planning document is one adopted by local authority resolution. So again, the legislature has put weight on something that an elected body of the council has resolved to adopt. And I also stress that definition refers to any non-statutory growth plan or strategy, which is not a district plan. Obviously, district plans are prepared under the Resource Management Act, as you well know. This is providing exemptions also for other strategies, such as a growth management strategy, or some other strategy or plan adopted by a council in a non-statutory sense. So both those limbs in my submission draw on the elected members of a council adopting, approving or notifying either a non-statutory growth plan or, in this particular case, variation 2, as having the key status that exempts the land subject to those non-statutory plans, or in this case, variation 2, from the transitional provisions of the NPS.
Okay. So that's consistency between clause 1 and 2, even though clause 1 is non-statutory and doesn't apply. The point you're making is there's a consistency in the adoption at council level of those documents.
Exactly, and the emphasis on being adopted, initiated, or by council resolution, I say, is a consistent thread through all those provisions. And stepping back from that and asking yourself, well, why is that? In my submission, the reason is that the legislature has identified that it's the elected members of council going through decision-making processes to identify future urban growth areas for a city or district. And if the elected members had chosen to identify those future growth areas on land that is currently classified as LUC 1, 2 or 3, that's a policy decision elected members have chosen to take. And the legislature has decided in promulgating this NPS that if that has been done at the commencement date by an elected body of a council, then so be it. That land has already been identified and is therefore exempt from the transitional provisions. So in my submission, it makes sense.
Okay, so I'll ask you a question now, and Commissioner O'Malley, if you have one, please ask as well. But just while we're talking about that that clause Roman numeral 2, I understand what you've just said. The word subject to a council-initiated plan change, etc. I did pose the question: if that was the intention, why is it saying subject to and not included within or as part of? But subject to sort of, to me, means or can mean the wider process of submissions, other parties being involved in the process itself. Do you think the word subject to are wider than what the interpretation you're giving?
No, I don't. And the reason for that is going back to the introduction at paragraph 7, where it's talking about references to land that at the commencement date was subject to the council plan to rezone it. And so what I'm saying to you or submitting to you is that at the commencement date, the land had to be subject to the council initiated adopted plan to rezone it. Yes. And so the rezone, well, clearly subject to means that it's part of the plan change, but that needs to be interpreted in light of the surrounding words that it's the council initiated or adopted plan change to rezone it being the land.
Yes. So are you, yes. So Mr. Garber, are you emphasising what you've put in your paragraph 19? When I first read that, I didn't really understand that point, or at least you're certainly emphasising it now, aren't you, in paragraph 19? Is that right? To rezone it. Is that the point you're making there, or are you making a new point?
Well, it is in part because it's talking about rezoning the land, but really I'm responding to other council where they've now argued the contrary position that any, as long as a submission was in train as at that commencement date, then that's enough.
Yes. All right. And I had another question actually. That's right. Just have you got any, while we're on that, have you got any response to Mr. McLaughlin's point about the word notified version? The clause does not include the words notified version is in clause B2. Is there any need to include that, or does the wording, which is subject to a council initiated comma or an adopted comma notified plan change? My question from a sort of a layperson's point of view is, does those first words, subject to a council initiated or an adopted notified plan change, does everything apply to the word notified? From a grammatical point of view, for instance, what do you take that clause to mean?
Yes.
Is that how you take it?
Yeah, so my submission and response on that is that this is tying back to the commencement date. So as at the commencement date of the NPS,
yeah,
there had to be in the system a notified plan change.
Yes.
So it had to have been notified prior to the commencement date to qualify for this exemption, but it also had to be of the character being council initiated or council adopted, which is distinct from a private plan change that council hasn't resolved to either initiate or adopt.
Right.
So I think Mr. McLaughlin identified that it's deliberately not covering private plan changes.
Yes, that's right.
But he was making the point, rightly so, that variation 2 was council initiated. So I don't think that's a particular moment here, because variation 2 clearly was council initiated and notified prior to the commencement date. So I don't think that's actually an issue that you need to necessarily grapple with.
All right. Well, we'll hear from
yes.
We'll hear from Mr. McLaughlin on that. Now, I've been asking you some questions. Did you have any other points you wish to make, Cass?
Well, I'm tackling that first issue. I want to go through your other questions, and there's a couple of other things. So that was really what I wanted to submit on that key issue about whether the exemption applies. So I'll move on to the next topic, and I did want, so that responds in large part to what Gladstone Family Trust and CC Otago Limited say. Yes. I want to respond briefly to a point Mr. Logan made in his submission, and he took issue in his paragraphs 8 with my phrasing of identifying in the substance of the NPS relevant considerations. And just in response to that, it might be more a merits issue about which are the relevant provisions, but all I was trying to identify for you which were the relevant provisions of the NPS. And I fully accept the point he makes, which I'd actually made in my submissions, that the obligation and statute is to give effect to the NPS. I fully accept that. But I was trying to use language to identify, well, these are the relevant provisions of the NPS that are engaged in the rezoning. So the point he makes, it's more than a consideration. So I accept that.
That's right. Yes, and I think there wouldn't be too much argument about that, I suspect.
No, I don't think so, but I just wanted to respond formally and address that.
All right, thank you.
I'll respond briefly to a point that Patterson Pitts made in their submissions, and it's really one I've already made to you, but they've placed emphasis on a strategic planning document being this district plan and the NPS. And I just specifically reiterate what I'd already said, that I do oppose that interpretation on the basis that strategic planning document is defined, as I've already taken you to, as a non-statutory document, which in my submission can't be a 2GP.
That's right. I did notice that as well. It relates to a that clause relates to a non-statutory document.
Non-statutory, yes. Yeah. So I say Patterson Pitts can't be right in their interpretation that the 2GP is therefore a strategic planning document.
That's right. Yes.
I'll just go through briefly and respond to the questions you have set out in minute 19.
Thank you.
So that I can address those. So firstly, question 1, how sites that may have a small percentage should be assessed.
Yeah.
And in my submission, it's simply a matter of that the objective and policies in the NPS only apply to land that is classified as LUC 1, 2 or 3. So on a site, those policies aren't engaged on aspects of that site that aren't mapped LUC 1, 2 or 3. Yeah. So that would be my submission. It's only engaged where you're actually dealing with highly productive land on a site.
Yes.
So that really gets into a merits discussion, the extent to which the NPS bears on a rezoning site if it only has a very small percentage, and that's issues of weighting of the NPS in my submission when you get there and if you get there. So I don't think it applies on blanket across the site if there's only a small part of highly productive.
Yes, I guess what our question was more in relation to, does the NPS direct us to call evidence, or to at least, like there's one site there that's got 0.2% of the land is covered by HP, but there is still a very small portion. So are we obliged to address it, or is there any discretion to call it de minimis or negligible? Is there still a need to call evidence on that 0.2%?
Well, in my submission, you need to understand the facts of whether there is highly productive land on a site, and I'm sure staff can draw to your attention the relevant highly productive land maps to.
They have, yes. I mean, that's that minute's comment on minute 17 from Mr. Morrissey sets out the sites that do have productive land, and there's one that's got 0.2, there's another that's got 20%, and then all of the others have got substantial, they've got 82% towards 100%, but for the ones that have very minute, or that one that's got a very minute amount of HPL, I guess we're obliged to address it if we determine that the legal submissions, we make a call that they are in fact included. We would have to address it in some form or another.
Yes, and that's my submission. You need to turn your mind to it and hear from parties on the merits as to the extent to which highly productive land is actually on the site or not, and then make a decision. On the merits. Yeah.
All right, thank you. Thank you.
Yeah. Question 2 was asking about strategic planning document, and I think I've addressed that a couple of times already.
Yes, you have.
Question 3, you asked about the purpose or intent of the NPS and how that might inform your interpretation, and I felt my opening response was really addressing that key issue as it relates to the interpretation.
That's right.
And you've asked me about subject 2, and I've addressed the ORC comment about relevant considerations. So,
there's another point. Yes. There was another point made by, I think it's Ms. Crawford and Mr. Page, about the Schedule 1 process. The purpose of the Schedule 1 process is to give public notice so that submitters can have an opportunity to propose alternative methods. I just wondered if you had any response to that.
Yes, so 2 points in response to that, thank you. The first is I absolutely accept we're in a Schedule 1 process and it's a public participation, and obviously parties have in scope submissions to seek rezoning of certain properties that you need to make decisions on. So that point is absolutely accepted. But I reiterate what I said in opening, that since this process has commenced, the government has promulgated the NPS, and based on my interpretation, it is right for you to assess the merits of those sites in light of the new national guidance based on the interpretation of the NPS I've put forward. So despite being in a Schedule 1 process, once you come to consider the merits of what is put forward, it's my submission the scheme of the NPS is such that the government is asking you to engage with it and assess those sites under the objective and relevant policies of the NPS.
Okay, I understand that. All right. The only other thing that occurred to me is there any parallels that can be drawn with the NPS UD, Open Development? Is there any parallels that can be drawn with the implementation of that NPS, which is reasonably recent, I guess? In terms of when it's what the rights of parties are, participation, whether there's for district plans that have been notified before the NPS UD came in. I mean, it's just something that occurred to me now, but I just wonder if there's anything that can be taken from that.
Yeah, I haven't done a line-by-line comparison about their transitional provisions, and I suppose the words of this NPS stand alone and need to be interpreted on their face in light of the overarching objective in my submission. So I haven't felt it important to draw parallels with other NPSs. Okay,
that's fine. I'll just check with Commissioner O'Malley.
Thank you.
Jim, do you have any further questions?
No, well, just sort of, no, I'm actually going to wait to hear the other council speak before I have any questions, because I think they're probably going to be more likely to address what it is.
All right, that's fine.
Thank you very much, Commissioners.
No, thank you for that. And we'll now go to the next one on the list was Gladstone Family Trust. So, Ms. Crawford, you're welcome to emphasise any points made in that legal submissions and to respond to what we've just heard and to our questions. Thank you.
Thank you. I'd like to just start back a bit further with first principles, in that the NPS is only concerned with highly productive land.
Yes.
Clauses 3.4 and 3.5 set out how regional councils are to map and identify highly productive land. In the period between when the NPS commences and the point at which the regional councils have completed their mapping and identification, clause 3.57 says that there are 4 criteria which need to be met for the land to be deemed highly productive. So what I'd stress to you there is that we're not dealing with 2 exceptions to a definition. We're dealing with 4 criteria which all have to be satisfied for the land to be highly productive. And in my submission, these criteria are not intended to require a merits assessment. They can be formed as yes/no questions about the land at the time that the NPS commences. Is it zoned rural? Is the land of the soil classes that are identified? In my submission, the merits assessment is the task of the regional council under clauses 3.4 and 3.5. In terms of the role of the deeming provision, if any of those 4 criteria aren't met, the land is not deemed highly productive land. That means that the objective and the policies of the NPS don't apply to it. They only apply to highly productive land.
Yeah.
We say that all of the land presently before the panel for consideration as part of variation 2 doesn't meet the 4th criterion. And as a result, it's not highly productive land. Therefore, you don't have to consider the objectives and the policies of the NPS in giving effect to the NPS.
Just remind me, what's the 4th criterion?
So what I'm saying is that at clause 3.57, we have A, which is the land is zoned rural or rural production.
Oh, yes.
We have A sub 2, which is LUC 1, 2, 3 in land. And then we've got 2 in the negative. So it's not identified for future urban development, and it is not subject to a qualifying plan change process. So the conversation we've been having has centered around looking at these as exceptions, the clauses in B as exceptions to A, but they are requirements to meet the deeming definition of highly productive land.
Now, have you, what you've just conveyed to us, have you included that in the written submission, or is this something new?
This is new from my submissions, but I thought it was a good way to kind of reorient. It's a response to your question about the purpose of the NPS. So in terms of looking at the purposes of the NPS, we have the objective and we've got the structure of the NPS. And the structure of the NPS tells us how highly productive land is to be defined. And the NPS only deals with highly productive land. So in terms of your task of considering our submissions about these requirements, that we're dealing with a definition rather than an exception to a definition. Right.
And so because I haven't got that written in front of me, I'm just trying to understand what is the knockout blow in that sense? Why do they not have highly productive land? What's your argument about that again, please?
My argument is that this land can only be highly productive if it satisfies all of the requirements in 3.57. So it's highly productive if it satisfies A1 and 2.
Oh, I see. Yeah.
But we've got 2 exceptions for it. It has to satisfy all of the criteria.
Yeah. And so why does it not satisfy the 4th criteria then?
So in my submission, it doesn't satisfy the 4th criteria because that criteria refers to a specific point in the Schedule 1 process.
I see.
So that it's requiring that the plan change be council driven. So it's either council initiated or adopted. In this instance, we've got a plan change that's been council initiated. It needs to be a notified plan change. And in my submission, the notification is telling you at what point a plan qualifies for the criteria, not the words that set the boundaries of what land qualifies to meet the criteria.
Okay. Okay. I think it would be useful to have a, if you're able to provide us with a written, writing, because I'm struggling to understand that. And it might be that if I ask the other council to respond, they can either agree or disagree, but they might make it clear as well. I think I understand the gist of that, but we'll ask for their response as well when you've concluded.
Yeah. It's I guess it comes down to the definition of highly productive land, which is what we're grappling with as a topic, is what is highly productive land. And I guess the guts of what I'm trying to say is that if these sites are not highly productive land, then they're not affected sites. They aren't affected by the objective. You don't need to do the merits assessment that.
Yes, okay, but we had that list of sites, or that table provided by Mr. Morrissey, the reporting officer, which I thought was a factual statement that they do have highly productive land on them.
Mr. Morrissey's statement says that those are sites which are zoned rural and that have land classes 1, 2, and 3.
That's right. So
that is not all of the requirement of the definition.
Okay, so what parts? I'm struggling to understand that they meet clause 1 and 2 of A, don't they? So they are zoned rural production. They do have LUC 1, 2, or 3. And just remind me your argument as to why that's not highly productive land.
On our interpretation of the council initiated plan change subclause, that they don't meet that requirement.
Okay. All right. We'll ask for a response from the others on that, so we can discuss that one. But thank you. Right. And do you have any further answer to those questions, or are they not related to your main submission, the questions we've posed?
I can respond to the questions. In terms of the purpose of the NPS, while it doesn't have a stated purpose, I'd say that functional difference between what the deeming provision is designed to do. So the deeming provision is designed to create a simple gateway for land to either be highly productive, either be treated as highly productive or for it not. In the interval between when the actual merits assessment is supposed to be undertaken by the regional council. And so the functional purpose of the deeming provision is not to have recourse to the merits assessment that Mr. Garbutt is inviting you to engage in.
Okay. All right, thank you.
In terms of the use of the words subject to, I think that my submission is that it's deliberate. So the legislature could have drafted B to read is not identified in a council initiated notified plan change to rezone the land, but it didn't. It chose to use the phrase subject to, and I think that in conjunction with the fact that council initiated, adopted, and notified are all descriptions of the plan change process under Schedule 1, indicate that the purpose was to go, here's a plan change that's rezoning land from general rural to rural production. So if the plan change can rezone that land, then that land is not highly productive.
Yes, I understand that. So that's the counter argument, yes, to what we've heard from the council, the Schedule 1 process. Yeah, okay. All right. I understand that. Did you have any other points you wish to make? And I'll ask Commissioner Miller if he has any questions too.
I guess the final point I'd like to make is that the OSC's sort of comments about irrelevant considerations and strong considerations, we agree that the panel has to give effect to the NPS. It's just our submission that the panel's giving effect to the NPS is applying its definition on its terms, and that results in the land for the panel for consideration not being highly productive land.
Okay. All right. Thank you for that. Commissioner O'Malley, do you have any questions?
Yes, well, I think so. I mean, yes. I think we are sitting around 7B2 quite heavily in the submissions. And are you saying, Ms. Crawford, that basically, if we're looking at the totality of the list of sites that would be exempted, so it is not, that you're suggesting that we should be looking at everything that's being considered under the plan change? That means council nominated sites to start with, and then sites that came in at request to be considered during the plan change. I take it that's the crux of yours, as opposed to Mr. Garbutt's position that it was only the sites that were listed in the notification process that are exempted.
Yeah, that's the crux of what I'm submitting, and that the reasons for that, I'd say sitting in behind that, is that the Schedule 1 process anticipates that there are going to be other methods proposed by submitters. And also, I think that it's relevant that the NPS was developed in the knowledge that the NPSUD was out, which is requiring councils to engage in a range of plan change processes like Variation 2 to give effect to their NPSUD obligations. So in my submission, the legislature, through this clause, is trying to create a space for Tier 1 and Tier 2 councils in particular to finish the work that they've started under the previous national direction in relation to urban development.
And that these sites are subject to this plan change, therefore they're consistent with the wording of the NPS.
That's my submission.
Right, that's good. Thank you.
All right. Thank you for that. Now, we've got no further questions of you at this point, but I will give Mr. Garbutt an opportunity at the end to respond to that and the other council who are participating, which Mr. Logan and Mr. McLaughlin might wish to comment as well. So thank you very much for that. And just before I finish, if you are able to please, mainly for my benefit, I guess, is to provide a very short written confirmation of that discussion on that you've raised today about the qualifying criteria. Just for the record, really, where people have an opportunity to respond today, but it'd be good to have it on record, that argument. So thank you very much. If you can do that, and if you're able to do that reasonably soon, that would be even better. Thank you.
I will do.
All right. Okay. Well, now go to Mr. Logan. Thank you, Mr. Logan. You're welcome to address us on your point and any response to the matters you've heard today. Thank you.
Yes, thank you, Commissioner. I probably don't need to say a great deal about the key point made in the written submission, because that now seems to be common ground amongst other council addressing you today. Yes. What I would like to do, however, is respond to some of the submissions which took issue with Mr. Garbutt's written submissions, because I hadn't had the opportunity of commenting on them earlier.
No.
Now, I'll begin by adopting what Mr. Garbutt has said to you orally today. I agree with the substance of that, and I will just make some supplementary comments to try and assist the commissioners in their deliberations.
Thank you.
The key issue focuses around the construction of clause 3.5, subclause 7, and that deems land to be highly productive land where it is either zoned rural or rural production and is LUC 1, 2 or 3 land. So that's 7A. Then there are 2 exceptions to that. B1, identified for future urban development, and for the reasons which Mr. Garbutt has given, that exception can't apply. And I agree with his rebuttal of Patterson Pitts Group's submission. There simply isn't a future development strategy, and there isn't a strategic planning document in the sense used by the NPS. So we can put B1 to one side. It's simply inapplicable. The focus for you is the difficult issue of the proper construction of B2. That's the nub of the case. Now, I agree with what Mr. Garbutt has said both in writing and orally on that provision, and I'll just give you a couple of, or 3 quick points as to why. Firstly, it is land that is subject to a council-initiated or adopted notified plan change. The words subject to a council-initiated or adopted notified plan change must, in my submission, be read as a whole. And when you read them as a whole, it takes you to what was notified. And the land which the submitters seek to include in Variation 2 and rezone from rural to residential purposes is not subject to the notified plan change.
Right.
So the second point is that B2 talks of a plan change. we're not dealing with a plan change. We're dealing with a variation. And I say that because if you go back to clause 1.3, subclause 3 says, subclause 2, terms defined in the Act and used in this national policy statement have the meanings in the Act unless otherwise specified.
Right.
So what is a plan change? Well, we go to section 43 AA, that's capital A, the RMA, and a change is a change proposed to a plan. What is a plan? A plan is a regional district plan. What is a district plan? A district plan is an operative plan. 2GP is not an operative plan. The section 43 AA goes on to define a variation, and that's an alteration by a local authority under clause 16A of Schedule 1 to a proposed plan. So in promulgating the NPS, the makers have deliberately used the language plan change as defined in the RMA and haven't included variation, which is a different RMA concept.
Right.
And so in my submission, if I'm correct, B2 doesn't come into play at all.
Right, okay. I understand the point you're making, yes. And is there any reason why, if that's deliberate, if that was deliberate, is there any sort of logic behind that, do you think? Why a variation would not be included? Because a variation is closer to a district plan than a plan change is, isn't it really? It's sort of like it's, I always interpreted or understood it to be a variation to be a plan, but you're saying it's not the way it's defined.
Well, and I agree with you in a practical sense, but the technical language and the definitions given in the Act, which are adopted by the NPS, make them conceptually different from a legal perspective.
Yes, because that would include private plan changes, but well, it seems strange. It seems a strange situation to be in where a private plan change would be included, but not a variation. Yeah, okay. Anyway, I understand that.
Well, a private plan change would only be included if it were adopted by the council.
By council, yes, that's right. Okay. All right, I'd be interested, Mr. Garvin and Mr. McLaughlin and Ms. Crawford, I guess, as to whether you have any views on that point, because that would simplify things if that was the case. It would be a fairly straightforward thing, but I'm interested to hear your views on that.
Yes, and the third point that I'd make, and this is in response to the argument that's based on, well, we're in a Schedule 1 process and the plan's been, the variation has been notified, people have made submissions on it, they're seeking to extend its spatial extent in terms of rezoning of land for residential purposes. It's a common legislative technique to say that a new legislative instrument doesn't impact on processes which have already been commenced. Now, that technique hasn't been adopted in this case. There is no savings or transitional provisions which bite on this particular situation. We know that these kind of processes are going on all over the country at any one time, and yet the makers of the NPS have not made provision for them. And that suggests that the argument that land which is the subject of submission for rezoning is not to be taken account of, is not to be excluded under B2.
Right.
And that really goes back to reinforcing the point that Mr. Garbutt and I have made about the words council initiated or adopted notified plan change. notification really sets the boundaries. What is in the document at the time of notification is the extent of the exclusion.
Yes, and just something that occurred to me is the issue of scope. You mentioned that the submissions seek to extend the spatial extent of the variation, but as far as I'm aware, the sites that we're considering, the requested sites, are generally almost all exclusively within scope. They're extending the spatial extent, but they're deemed to be within scope of the variation. Is that relevant?
Well, I'm not taking an issue with the jurisdictional scope.
No.
What I'm saying is that they're seeking to rezone land at the council in developing the variation for notification has chosen not to include in its initiated
in the initial
notified document.
Yes. And I suppose it goes to the intent where the council intended that to be an inclusive list and not add any sites to it, or whether the council had in mind when it did the notification that it might include some new sites as part of the submission process. That might be relevant too, I suspect, but I think you're relying on you're certainly emphasising the words as they appear and asking us to focus on those words.
Yes, and what Mr. Garbutt has illustrated for you is that there's a commonality to B1 and B2, and that the exclusion applies to land that has the sort of council stamp on it.
I see.
Either for a future development strategy or some other strategic document adopted by the council, or under B2, what it has chosen to notify to be rezoned for residential use.
Yes, actually, that's a nice phrase. Has the council stamp on it. I can understand that point you're making. All right. No, look, I think Commissioner O'Malley, we understand that point you're making. So,
I do have a question.
You do have a question on that. Thank you. Yep. Ask it now.
Well, it's just, Mr. Logan, you're saying then that this variation is not a plan change.
Yes, I am. In the sense defined by the Resource Management Act.
Right, so therefore nothing under this variation is exempted then, even the Greenfield sites, because if the variation itself is not a plan change, therefore we don't have anything in section B2. It means our GF sites are also subject, by that interpretation, GF sites would also no longer be exempted either.
Sorry, your GF...
The council-initiated sites, which have got
well,
GF.
You're right. There would be a problem in that respect. Yes.
Yeah, I understand that.
Well,
thanks for asking.
Effectively, be a total knockout of everything. Everything would be not exempted.
And that would mean
well, it means that the provisions of the NPS apply.
Everything is now every site, including the council initiated ones, are now subject to the NPS.
So if that's correct, it means that the NPS there's no real exclusions, are there? It means that the variation there's no real exclusions other than a private plan change that's been adopted by council.
It's been adopted by council. That's the only exception if we take that interpretation.
Yeah.
Okay. Thanks.
Okay, we understand that. Thank you for being very clear on that, Mr. Logan. That's great. Thank you. We could probably just move to Mr. McLaughlin now. So thank you, Mr. McLaughlin. You've heard all that discussion and you've got your own points to make, so we'll be in your hands.
Thank you, sir.
Yeah, thank you.
Good morning, Commissioner O'Malley. Mr. Garbutt started at discussing the purpose or objective of the NPS. Objective 1 starts with the wording highly productive land. And so the objective will only apply to highly productive land as defined by the NPS. And so naturally we go directly to the definition of highly productive land as to whether that objective applies or should be used as guidance yet. Yes. The first section of the definition of highly productive land says that it must satisfy clause 3.4 or 3.5. if we were to take a snapshot now without the rest of that definition, the NPS wouldn't yet apply because those two clauses have not yet been satisfied. And so I think that's what Ms. Crawford was getting across to you, is that unless you do meet the definition or the clause 3.5 sub 7, we do not yet have a situation where there is highly productive land and the NPS does not yet apply. Where council officer has identified land and called it highly productive land, that is a council definition. That is not the definition that is used by the NPS. And so we still need to go through this interpretive exercise before we can say whether these objectives and policies within the NPS are relevant.
Right.
Because the NPS is not relevant to land that is not highly productive. And the directive objective 1 doesn't apply unless the NPS applies. And so we have to first satisfy whether an exemption applies before we look to the NPS for guidance.
Okay, thank you.
The wording that follows in the definition of highly productive land says what is to be treated as highly productive land. And so it acknowledges that there is a distinction between the land that meets clause 3.4 and 3.5 and to what in the interim period is to be treated as highly productive. So there is a wee distinction there. And in my submission, unless it is treated as highly productive, then the objectives and policies within the NPS are not yet relevant, including for guidance. We shouldn't use the directive objective 1 to shoehorn in other sites simply because it is directive.
Yeah.
And so I want to just jump straight to 3.5, clause 7.
Yes. Okay. Yes.
So clause 7 is quite clear that it is the transitional provision.
Yep.
Until clause 3.4 and 3.5 are satisfied, then this is what's relevant to us. And again, it uses the term as if it references to highly productive land. It again acknowledges that there's a distinction between highly productive land that meets the definition of HPL, being that first section, and then the land that meets or is to be treated as highly productive land in the interim period.
Right, distinction, yeah.
And so I'll follow through the wording, follow it references to highly productive land with references to land at the commencement date. And so the commencement date is the commencement date of the HPL. And so we are looking at a snapshot in time at that date. And that includes, and as I followed through in my submission, it includes where the council have initiated, adopted a plan change, including the sequential steps that that plan change has gone through. If the NPS intended it to capture just at the date of the notified version, at the date the plan was notified, then that is where the wording should be included. But instead it says commencement date.
Yeah. And can I ask a question on that now? Just in terms of the language, you've suggested the word notified would have been included earlier in that clause as well as at the latter part of the clause too. You don't read them conjunctively, that they read as one sentence and there's no need to put the word notified at the start of it. You don't agree with that?
The drafters could include notified later too if they wanted just to apply to B subsection 2. But the point here is that they didn't include it at commencement date at the top, and they could have.
Commencement date, yes, okay.
And so in my submission, that's the date at which you're assessing. And that becomes particularly relevant when you get to sub 2.
Yes.
When I look at clause 7A, that is the exercise that council planner has undertaken.
Yes.
But it has not grappled with B 1 and 2 yet. And so I support Ms. Crawford's submission here, saying that they've done the partial exercise, but we still need a further interpretive exercise to define what is highly productive land or what is to be treated as highly productive land.
Right. Is that an interpretive exercise, or is it based on legal submission?
It's perhaps the definition of how far you extend the definition of future urban development is potentially subject to planning, but I'd say it's largely legal submission, sir.
Yes, that's right.
And we are trying to interpret what clause 7 here means.
Right. Okay. All right. Understand that. Now, thank you for that. Sorry,
sir.
But carry on. But just before we move off that, if we do, I asked Ms. Crawford to provide a brief summary of that discussion. I would invite you to join with her if you agree on that, to provide a joint statement. It can be very brief, but just to put in writing those points. I think you've touched on those in your legal submission, but you're just elaborating on them now and sort of clarifying.
Right,
it would be useful.
I'm introducing any new concepts yet.
No, but it would certainly be useful to have that written down, so when we do our evaluation of it all, we can have in front of us. So thank you. All right.
Turning to subsection 7, clause B, which is framed in the negative.
Yes.
It says identified for future urban development. In my legal submission, I accepted that did not apply here.
Yes.
And so I don't intend to go any further on that at this point.
No. Okay.
Subsection clause B, subsection 2.
Yeah.
This is the one that is causing debate currently. In my submission, sir, subject to connotes a broader interpretation. It's not saying as identified or specified within a council initiated or adopted plan change. It is taking the broader approach where if a plan change has been notified and a member of the public is impacted by it and has scope to engage with it, whether they are impacted positively or negatively, then they are subject to it. If their proprietary rights or the use of the land is impacted by a plan change, then they are subject to it.
Yes.
Their rights to participate in that process are protected by Schedule 1. And to take a different interpretation would effectively subvert their ability to participate in the plan change process on an equal footing to council. It effectively allows council, through the notification and original evaluation assessments, to get the benefit of regulatory documents that don't apply equally to everyone. It's my submission that the council stamp, as referred to by Mr. Logan, doesn't carry that much weight.
Yeah, just trying to understand that point about council benefiting. Is council really benefiting? What you mean is the Greenfield or the GF sites would be treated more favourably than the RS sites, but there's no real benefit this here.
In my submission, so you have regulatory obligations when you assess proposals put forward in a plan change.
Yes.
And I quite liked the way Mr. Garbutt phrased this at a previous hearing, where he says, but where you have competing proposals, you have to assess which proposal best gives effect to the objectives of the plan change and the purpose of the Act.
Right, okay. Yeah.
And if council are exempt, council sites as notified are exempt from the NPS HPL, then the HPL doesn't apply to them, but it applies to everyone else. When you are undertaking your comparison assessment, you are therefore having to assess the proposals under different regulatory regimes.
Yeah, okay. And is there anything you could comment on regarding that question about scope, that the notification included GF sites, and is there anything that we should take into account that the council may have expected there to be other sites added to that list as part of the submission process? Is that something that's relevant?
The scope determination, acknowledging that it's made under a different set of provisions in the Act, still determines what members of the public have been acknowledged as being impacted by a plan change and therefore can submit on it, and to the extent that they can submit on it. And so those constraints are the parameters in which subject to should be interpreted.
Yeah, all right. And that's, I fully understand that point you're making. That's one of the reasons we put that down as a question for the parties to comment on what that meant. And we've had two different submissions on that. So thank you, understand that. Very good.
What I will say, and I'll jump to the wording rezone it, because Mr. Garbutt focused on that today.
Yep.
The wording it can still be achieved through submissions of a submitter. Even if you take out the words that I've proposed that Mr. Garbutt is attempting to insert, rezone it sequentially has been achieved as these sites are subject to a plan change and submitters have sought rezoning of site at the commencement date of the NPS. There is a plan change that these sites are seeking to rezone that land itself. And so that wording has been achieved.
So that's a point that probably hasn't been discussed a lot today, is the commencement date of the NPS, and that you're very strong on that in your submissions, aren't you?
Yes.
Yeah, okay.
So when you look at the commencement date, you take a snapshot of where this plan change is sitting in the regulatory process.
Yes.
And who is subject to it.
Yes, okay, understand that. All right.
In my submissions, I've outlined why the legislature has used the wording initiated and adopted. And the reason for doing that was to acknowledge that accepted plan changes aren't included within the scope of this exemption. I don't think there's any dispute or dispute amongst that. The last wording there is notified plan. And I have stressed the importance of this wording in reference to Schedule 1 of the Act. There are, under scenarios, whether it's initiated or adopted, Clause 5 is triggered, and then Council must notify that plan change. That then opens the plan change up to submitters who can submit on it, and then they can only submit on that plan change if they are within scope and therefore subject to it. And so in my submission, notified plan is telling you that that regulatory step is undertaken. It has already been undertaken before commencement date.
All right. Understood. I think that's pretty clear. Thank you.
And I've addressed the wording rezone it, and I accept Mr. Garbutt's submissions in relation to general rural and rural production land being the equivalent references, because the 2GP hasn't yet adopted those definitions.
Right.
I think so that captures what I want to address here in relation to that clause. I'll make one comment in relation to relevant considerations and strong considerations as raised in Alistair Logan's submissions.
Yeah.
It has been our submission throughout, sir, that where you have a national policy statement that is triggered or is relevant, you must give effect to it. And I reiterate that that applies both to the NPSUD and the HPL.
Mm. Yep.
Other than that, sir, if you have any questions.
I think we've covered a lot of all of the issues really that I for me anyway. Commissioner O'Malley, did you have your hand up? Yep.
Yeah, I'm Mr. McLaughlin. I'm just looking for what Mr. Logan referred to as the council stamp. And are you suggesting potentially that once the scoping ruling had been done and that those sites had been ruled as being in scope, they had effectively received the council stamp, as we're calling it, and therefore are now subject? Is that the central piece of your argument in some respects?
No, I'm saying the council stamp isn't the be all and end all as proposed by the City Council and the Regional Council. If that has been assessed, even if it is declined, or not notified as being rezoned by council during that notification process, because it forms part of that Section 32 assessment, it is therefore subject to the plan change. And whether or not council recommended it to be rezoned or not should not be determinative of whether this exemption applies.
Oh, I wasn't saying, when I was referring to council stamp, I was using a fairly loose term to say that effectively it has now become part of the council process because it was accepted in the scope aspect, an RS site, before the commencement of, before the plan, before the national policy statement takes effect.
Well, it's my submission that if it's within scope, because council considered it as part of that the 32 assessment process, then yes, this exemption then
is now subject to the plan.
Yes, that's right.
Yeah.
Thank you.
All right. Thank you, Mr. McLaughlin. We've got no further questions at this point, but thank you for making those points.
Thank you.
And if you do want to assist Ms. Crawford to collectively provide a statement.
If I may, I hadn't considered Mr. Logan's point in relation to plan change, and I'd seek the opportunity to file further written response to that, having worked my way through those definitions.
Yes.
I'd appreciate the opportunity to file some written response to that.
Yeah, thanks for reminding me that's a key point, and we would invite comment from all the council on that, particularly Mr. Garbutt as well on that, because that needs to be addressed one way or the other, that's for sure. Thank you for that. If everybody could address us on that point as soon as possible, would be really good. We're hoping to make some determination on this next week if we can.
Thank you.
All right, thank you. And now, I suppose it would be really useful to have Mr. Garbutt's response to some of they're not new matters, but they're certainly put in a different way that we've heard today from some of the council. Are you able to respond, Mr. Garbutt, to some of those things? Or any of those things?
Yes, thank you. If I can start by responding to Ms. Crawford's submissions to you, and she was trying to draw out a point along the lines that there's 4 criteria, all of which need to be satisfied. And to the extent I understood what she was trying to argue, I mean, there's no dispute there's 4 elements in subsection 7.
Yeah.
Really, I think all council have said the key interpretation issue is what's meant by B2. So whether that's really the crux of the issue before you. I don't think it advances matters just to argue that there's 4 criteria. It's fully accepted there are, and I don't think that really bears on the interpretation of what's meant by B2, which is the crux of what you need to interpret.
Okay.
I should say also that I certainly don't resile from my submissions I've made to you and open from anything I've heard. I stand by the interpretation I've advanced and maintain that's the correct interpretation. In terms of Mr. Logan's submissions, he's made the submission to you that variation 2 isn't in fact a plan change and it's not part of the exemption. That's not accepted, and I will perhaps take up your invitation to put something in writing on that, but it's important to understand, and I'll address you now on it briefly, that variation 2 is seeking to amend deemed operative provisions of the 2GP. And you may or may not be aware, but it's now listed on the DCC website as having got the heading plan change, DIS-2021-1, and in brackets variation 2. So in my submission, it does have the characteristics and status of a plan change, being initiated as a variation, but now has the qualities of varying deemed operative provisions of the 2GP, being those that aren't subject to any appeal. So the council does take the view that it does fall within the definition of plan change for the purposes of the NPS as it's used in clause 7B.
Right.
The next point, I just want to address a point you made, Commissioner Ray, in questions to Mr. Logan, and you did ask something along the lines in my notes that whether it's relevant when the council initiated variation 2, it was obviously aware that other sites could come in via Schedule 1 process. And in response to that point, I simply submit to you that it's always the case at every plan change or variation, there are submissions that refine, change and add to a plan change or variation, but that doesn't assist us in interpreting what's meant by the exception in para 7b, which has to be interpreted in the words that are there. Knowing that other sites may or may not come in, I don't think necessarily determines how B2 should be interpreted.
Okay, right.
There's one point Mr. McLaughlin made that I'd like to respond to, and he was arguing that the interpretation advanced by myself and supported by Mr. Logan puts the land that council identified in its notified and initiated plan change in somewhat of a different category to that advanced by submitters, and seem to be saying that that is in some way unjust or incorrect. And in response, I say, well, that's the choice the legislature has made here, and has, in my submission, expressly identified a council stamp as having some particular moment in time, being a point in time which can be objectively identified by any person, and knowing that the world can know at the point when the plan change is notified what land is encapsulated in it, and that is included in all the Section 32 material, the notified version and the public notice, so that people can identify at that point in time exactly the bounds of land that is encapsulated in the version of the plan with the council stamp. Land that is sought to be added by submitters often isn't subject to Section 32 analysis in terms of its benefits and costs, nor its alignment with higher order documents such as the RPS, or in this case the NPS, UD or any other NPSs. So in my submission, it's logical and deliberate that the legislature has identified a council stamp, if you want to use that phrase for convenience, as having a particular status or moment. The other point I'd make is to support that submission is really a practical one, in that sometimes submissions come in that are by laypersons. They may well be very general or extremely wide in their ambit, and they may in fact sometimes be quite vague in terms of the bounds of the land that they apply to. And if the interpretation Mr. McLaughlin and Ms. Crawford advance is correct in law, then any person who has made a submission referring to any land is then exempt from the provisions of the NPS. And I say to you that's not correct, and that's not what was intended by the legislature when they were deliberately, as I say, identifying a council stamp has a particular gravitas that it is intended to have a status that distinguishes from other land that may come in via the Schedule 1 process. So for all those reasons, I stand by the submissions I've made to you, and leave you to make a decision and wish you well with it.
Yeah, thank you. And that last point you made about the Section 32 assessment and the differentiation with people who lodge a submission that could be potentially vague, and I must say we may have seen some of those that are certainly less detailed than some of the GF sites as part of the plan change variation. Have you made that point in your legal submissions, your written legal submissions? I know you in 4B you've said included valuation under 32AA, but if you haven't made that, what I was going to suggest was that give all of the parties a chance to give us a very brief supplementary submission, I guess, mainly emphasising the points that have been made today, because I think some of those points are really worth considering in further detail, having them written down so we can fully evaluate them. So I'd invite first of all of the legal counsel to comment on that definition of variation and plan change, and possibly if Mr. Garlick can provide your confirmation of the way you've interpreted it in terms of the way the variation is now referred to as a plan change because it relates to operative parts of the 2GP. If the other council agree with that, that would help us, I think, or if they disagree with that, that also help us. That's a key point. So if people are able to provide us with some comment on that in the next few days, we'd appreciate it. Thank you. And also to confirm any other key points you've made in a concise fashion, that would help us. All right. I think that's all the questions we have, and it's been a really useful session. And you're right, it could be quite an interesting and difficult exercise for us, but we do intend to grapple with it fairly quickly and make a decision on it. And the panel may well seek independent legal advice on this. We have done that throughout the process. We've done it at least one time. And if we do that, we will certainly invite responses from the parties to that advice that we receive. So rest assured that will happen. And I guess one of the reasons I'm asking for anything to be written down, it will assist any independent legal advisor to understand the discussions we've had today, if you're able to do that. And if I can be so bold as to suggest a time frame for that, I'd really like to receive something by Wednesday next week. I know Monday's a holiday, so it's very short notice, but that would assist us to have something issued by the end of next week. So thank you for that. Anything else, Commissioner O'Malley, you wish to raise? I think we've had a good discussion of all the issues.
I think we've had a fairly clear discussion of all the issues. I just want to ask Mr. Garber, commas can be problematic when we're trying to interpret things, and when you read that section B2 and you take out or and adopted, you end up with council initiated notified plan. And do you think it's meant to be read in that way? So, and therefore it was what was written in the notification at the time, only those sites. And that is pretty much your argument, is it not?
Yes, that's right. But it is read as a whole, but it's tied to what the council initiated or adopted, which is the version of the plan that went to the elected members of the council, not what subsequently comes in by people's submissions through the Schedule 1 process.
And I feel that we're balancing that with the fact that this is a plan change that is currently in motion, that the RS sites are subject to it.
Well, the RS sites are within scope of the plan change, but they're not subject to a council initiated or adopted notified plan change in the sense that we've interpreted that being the version that went to council that was adopted, because the submissions obviously came after the council adoption.
That's the crux of the matter.
Yeah, so there's a timing issue there also, that when council initiated or adopted this plan change, submissions didn't exist, and they obviously came in through the Schedule 1 process later. So they couldn't have been part of the council adopted plan change at the time council adopted it.
Okay. Until we have finished our adjudications on the whole plan change, so has the council really adopted this plan change, or is it's initiated the plan change, right?
Yeah, we're dealing with an initiated one. Yeah, that's right.
Initiated.
Adopted is normally a private one adopted. So yeah, sorry, it's council initiated. Yeah.
Another plan change. Okay, thank you.
Thank you.
All right. And was it a plan change at the time it was notified, or was it a variation? Is that an important distinction? Yeah, I just pose that question to anyone who wishes to respond on that. Subject to a council initiated and notified plan change. We're hearing that it is a plan change now, but was it at the time? was the 2GP beyond appeal. That's, I imagine it was beyond appeal.
I think the relevant in there is the commencement date, which is the 17th of October.
Yes, okay. All right. Thank you. I think that's it for now, and unless anyone wishes to raise something now, but we do appreciate all your assistance and the work that's gone into presenting these arguments to us, so thank you very much. I'll just issue a minute, when we close here, I'll just issue a minute to confirm what we've agreed on, what I've asked for here for the record. So thank you very much. Close the session for now. Keep the hearing adjourned, obviously.
Thank you, Commissioners.
Thank you all.
Thank you, Commissioners.
Thank you.